So what we just talked about was like the definition of legal personhood and so on, and then we sort of wanted to assess this orthodox understanding of legal personhood. And because the orthodox view understands legal personhood in terms of the holding of rights, so then we looked at what modern theories of rights understand as rights. And now we can present my discrepancy argument, right? So first of all, this is the extension of legal personhood. So this is who or what we take to be legal persons in Western law. So there are children, adults of sound mind, people with mental disabilities, corporations, and so on. They are all legal persons, whereas, well, fetuses are a difficult case, but groups that are not corporations are not legal persons, non-human animals are not legal persons, slaves were not legal persons, and so on. So this is how we understand the extension of legal personhood. And if the orthodox view is right, then it should be exactly the same with regard to right holders. So we would then we should then sort of say the same thing about rights. So children have rights, corporations have rights, adults have rights, people with mental disabilities have rights, slaves didn't have rights, non-human animals do not have rights, non-incorporated groups do not have rights, fetuses do not have rights. Okay, they should be exactly equal, right? If a legal person equals a right holder or a duty bearer, but let's not go into that here. But if we then take these theories of rights, we get very different results. So we take the interest theory, even if we don't go into the sort of controversial questions such as whether trees have interests, but I think it's quite incontroversial to say that animals, for instance, have interests. So we actually get a much bigger group of right holders, right? So slaves were protected in, say, antebellum United States. So actually, we could say that slaves held some limited legal rights because they were protected in a way that sort of benefited their interests. So the interest theory would ascribe some limited rights to slaves. We protect fetuses, at least toward the end of the pregnancy. Not, of course, like as robustly as we protect, born human beings, but I think more or less all countries regulate abortion to some extent, even if it wouldn't be very robust, but abortion is somewhat regulated. We protect non-human animals, and the interest theory would very straightforwardly ascribe rights to non-human animals. There are animal welfare laws, and because we protect animals, we protest the duty not to afflict animals with undue suffering. Animals hold the correlative right not to be afflicted with undue suffering. This follows quite straightforwardly from the interest theory of rights. So, if we follow the interest theory, this sort of equation that right holders and legal persons are exactly the same beings. On the other hand, if we follow the will theory, especially sort of one of the more hardcore versions, we'll get a different result because we'll get some legal persons that don't hold any rights. So everyone agrees that, say, people with mental disabilities are legal persons, but actually some will theorists would say that they don't have any rights because so this is talking about people with very severe mental disabilities that cannot exercise their rights themselves. Of course, there's a lot of interesting research going on here, by the way, regarding how people with mental disabilities could have a kind of a supported agency, so other people help them exercise their rights. But anyway, Fetuses, well, it should have maybe be here actually. Again, fetus is a tricky case. It should maybe be on the outside. On the other hand, quite surprisingly, slaves actually did hold, if you consider the antebellum United States, slaves actually held some rights even according to the will theory, because slaves could, for instance, be prosecuted under criminal law and they could appeal those decisions. And that's actually a will theory, right? You can appeal a decision. It's up to your will whether you appeal it or not. So that's a will theory, right? Non-human animals are excluded here, probably. But you see, so they don't really interlock very neatly here either. So the discrepancy is then that is between who or what is widely taken to be a legal person, who or what holds rights according to modern theories of rights, and then the orthodox view, which says that these two should be equal. So you can have all three. Are you following the argument? You have to adjust something here if you want to have a coherent set of beliefs. And so what we then, what I sort of, how I described my work here was, what I was doing was that this is a question of a reflective equilibrium. I don't know if you've heard this methodology, but it's probably one of the main methodologies in philosophy. So I think actually very many philosophers engage with it, even if they don't make it explicit, but John Rawls made it quite famous, and Norman Daniels has developed it further. And the basic idea of reflective equilibrium in this sort of moral context is that you have three levels of beliefs, that there are like, so in moral philosophy you have moral judgments such as that, I don't know, torture is wrong, or let's say torturing babies is wrong, and then you have some moral principles, which is that torture is wrong, and some relevant background theories about, say, what kind of persons we are that could explain why torture is wrong. But then you might find some inconsistencies between these three levels, and then you will try to find some kind of balance, or rather an equilibrium, by maybe you need to adjust some of your beliefs about what exactly is wrong, or you might want to have to adjust your principles and so on in order to get a coherent overall set. Okay. So how I then applied it to legal personhood is as follows. So here, the question of who or what is a legal person is on level A. The definition of legal personhood is on level B. And then we have also relevant background theories on level C. I then argued that, so I mean, you would have to sort of adjust at least one of these levels. And I argued then that the best way of removing the discrepancy is by adjusting B, so adjusting the definition of legal personhood. That way, we can still sort of preserve the background theories, either the will theory or the interest theory, and we can more or less preserve who or what is a legal person. So it's, you know, and then I took it to have certain other benefits as well. So for instance, there's something that Daniels calls the independence constraint. So if we have level C background theories, so if the only thing these background theories do is support B and A, if they have no other purpose, if the only thing they're good for is to help with our understanding of legal personhood, then that's sort of a minus, because they should be good for something else. Otherwise, they're not really background theories. They're sort of very cherry-picked theories in that case. So if we then start changing our theories of rights merely to sort of work here, then we'll probably end up in problems somewhere else. So it will probably appear that those theories of rights are not good for explaining some other features of law. So it would be good to keep those constant. And I then offered some other reasons why I thought adjusting definition is the best way to go. So for instance, maybe I'll get, so the way I then conceive of legal personhood is in terms of cluster concept, so it can explain sort of gradual developments toward full legal personhood. And I also then criticize this idea of legal capacity, but it's actually mostly a private law concept. So let me say a couple of words about that actually. So as I mentioned, legal capacity in this context usually means the capacity to hold rights and or duties. And so it makes very much sense in private law, especially like property law and law of contract and so on. So for instance, because it gives us the right, so to say, to create rights and obligations between each other. So for instance, I can't enter a contract with my dog. I can't give property to my dog because the dog is not like a private law party in this relevant sense. And if the legislator were to change the dog status, then it would make more sense. Or then it would be possible. But outside of private law, and especially these areas of private law, I think it's a bit different. So if the legislator wants to protect animals, for instance, it's not really relevant. It doesn't like first need to give the animal some kind of capacity to have rights in order for us to call animal protection in terms of, describe it in terms of rights. This sort of legal capacity doesn't add to it. That doesn't add anything to the analysis. It's completely irrelevant or superfluous in a way. So if the legislature wants to protect animals, it can just give animals rights directly by protecting them in various ways. So I think this legal capacity idea is sort of a red herring in a way. Anyway, so those are sort of some of the criticisms of this orthodox view that I then present in the book. So do you have any questions? Did you sort of follow the argument regarding the discrepancy point? Do you have something?
Yeah, so I always find discussions of theories of rights deeply confusing.
Mm-hmm.
It's never clear to me what exactly is at issue and how we're supposed to decide, other than that maybe one fits with a larger theory that actually has some substantive output that seems useful.
Yeah.
Sort of philosophically useful. It seems to explain things or reach results that we have reason to believe are correct on other grounds, right? So I would have thought that if you're faced with a trilemma, at least intuitively, I guess my first instinct would be, okay, well, it looks like we need to just have a slightly different theory of rights because I have trouble making sense of how I'm supposed to decide between these two theories. So I'm sort of happy to revise there.
Right.
Yeah, I don't see the costs, in other words.
Yeah. I see the point, and I think you could make that kind of counter argument that actually there is no cost in revising our theories of rights. But I mean, the issue is that it's very hard to. So I mean, these both have their benefits, these theories, and it's surprisingly hard to come up with like better alternatives. So and I think like if you were to revise your theory of rights so that it fits with these extensional beliefs, then I think it would quite easily suffer from some inconsistencies. So I think it would still have to explain like what are animals missing them exactly. So I think the closest you could get is if you had a kind of a soft will theory, so the kind of will theory that allows for representation. In that case, you could probably have children explain, for instance, that children have rights because they have representation and animals don't have this kind of representation. But I think like there would still be issues of like so I was going to say that in criminal law, I mean, prosecutors still at least one sense defend animals or represent them if they prosecuted animal welfare crimes and so on. So and then there's the issue of like why exactly representation? Like how is it relevant? I think it's actually quite often falls back to the interest theory. You need an account of interests in order to have representation, and so it actually it's not that easy. At least I think it's not that easy to come up with a satisfactory theory that's sort of internally coherent and can account for these extension beliefs. But in the symposium that was recently published in this book, so there's a couple of people who argue that you can actually sort of salvage the extension beliefs by adjusting the theories of rights. Yeah. Anything else? Well, anyway, so this is my alternative claim. So legal personhood is a cluster property. So it consists of many elements that don't always come together. So that's why I call it a bundle theory. So sometimes you call certain theories of property are called bundle theories of property. So that means that ownership consists of various rights, and you can take away some of those rights or incidents, and it's still ownership. But if you take away too many, then at some point it stops being ownership. So, according to my theory, well, first of all, a legal person is either an agent, so I'm simplifying someone here, but it's either an agent, such as an adult human, or a collective agent, a group agent. We're going to talk about group agents later, or a passive right holder. Here I'm using by right holder, I mean, I'm not sure if I should be getting into it, but I'm employing the interest theory here to account for what kind of, in terms of what do children and non-human animals for personal rights. So it's one of these that is endowed with a sufficient number of what I call incidents of legal personhood. What is an incident of legal personhood? Well, there's a bunch. So there are passive and active incidents of legal personhood. So passive incidents are such that even, say, babies or non-human animals can be endowed with them, whereas active incidents are normally limited to, say, adult humans of sound mind. So you can actually consider the difference between this baby and, I mean, both of these could be passive legal persons, or you can see the mouse. Anyway, there we go. So we consider the difference between the baby and the cat. So both could be passive legal persons, but only the baby is. So what is it that makes the difference? Well, first of all, the baby is not property, the cat is. The baby can suffer legal harms, meaning that baby is a potential victim in terms of tort law. Okay, so if you harm the baby, you must compensate the baby. Whereas if you harm the animal, at most you have to compensate its owner. The body life and personal integrity of the baby are protected quite robustly. Of course, there is in a more limited sense, the animal is also protected, but it's much less robust. The baby can own property, the animal cannot normally. The baby can be the victim of a crime in this sort of, so again, we protect animals, but babies are more sort of doctrinally understood as victims, which provide, for instance, also procedural, it has like procedural implications. I discussed those in the book. Maybe even most centrally, the baby has legal standing. In the civilian sense, you distinguish between standing in the sense of partijtätigkeit, so the capacity to be a party. to legal to trials at all, and then standing in a specific case. So the baby has the capacity to be a party. And then the baby can be a party to what I call special rights, meaning for instance contracts. You can enter a contract even with a baby through a representative, whereas you can't do that with an animal. At least normally. I mean, so you have like some United States that have so-called pet trusts. In that case, you actually treat some pets to a limited extent as legal persons, in my opinion. But if we then contrast the baby with the adult, so first of all, the adult can sort of administer these things herself. She has what I call legal competences. So she can enter the contract herself. She can make the decision herself. She can represent herself in courts. Not necessarily, she might need a lawyer, but she can pick her own counsel and so on, whereas the baby can't do that. And she can be held legally responsible. Of course, like even relatively young children can, in some cases, be held legally responsible, like in tort law, maybe in Finland, even 5-year-olds have sometimes been held responsible to a limited extent. But still, like these are sort of the extreme ends. But one month-old baby and an adult who is considered to be of sound mind, and then you have like a middle ground in between. So it's not black or white in that way. Okay. Good. So here are then some alternative ways of understanding legal personhood or like persons. So first of all, if we think of it in these terms, it's not like there's a big wall between legal persons and non-persons, that you're one or the other, but rather we can think that as we have increasingly started to protect animals have sort of become somewhat closer to legal personhood. They're still quite far away, but they're somewhat closer. And they actually are what I would call subjects of animal welfare law, because it's actually inspired by Tomasz Pietrykowski that he distinguishes between subjects and persons, and I think it's actually quite useful here. And if we then consider the sort of inventory of the universe, it's also not like the black and white, but rather you have legal persons, you have sort of gray area legal persons, you have property, i.e. things, but you also have entities that are they're neither persons nor property. These are maybe the trivial examples, but for instance, rights are neither persons nor property. Perhaps more interestingly, if you're familiar with the idea of outlawry, so the idea that, like in the Middle Ages, people were kicked out of their societies. In a way, they lost all their rights, but they were not deemed slaves or anything like that. They were rightless, but they were not property either. So they were just outside of this person property dichotomy. And actually, this is maybe a bit misleading in the sense that some entities could be both. So you could have, for instance, there's a American legal scholar, David Faber, who has argued that animals could be given this, or should be given the status of living property, and that would be like they would still be property, but they would at the same time be legal persons to some extent. So they could, for instance, sue their own owners and demand compensation if the owner has mistreated them. So it's an interesting mix of person and property. But anyway, so why are animals not legal persons? I more or less already went through this. So they can't sue, they are owned, they can't receive compensation if they're harmed, they're very weakly protected, and so on. So it's not just that because they don't hold any rights at all. If you're an interest theorist, you can say that, in fact, animals already hold some rights. They're very limited rights, but there's some rights. But animals are still not legal persons. That's what my theory allows you to say. Any questions? about theory, for instance? Yeah.
I think that I wonder whether the orthodox view has one advantage over your general theory, and this advantage is that orthodox view provides more unequivocal criteria of being a legal person than your other theory.
Yeah, I mean, in a way, that's I think you're right. But then you can ask whether it's a good or a bad thing, in the sense that if we get into the gray areas, the orthodox view, I think, is in some difficulties. So, for instance, again, if we think of like women's gradual development toward full legal personhood, I think my theory can better explain how it's gradual. And one thing that I was discussing with someone here like 2 days ago is, because I mean, our legal systems have a vast number of like different kinds of company arrangements, and some are considered legal persons and others are not. And it's very counterintuitive which are considered legal persons and which are not. And I think, at least to me, it's counterintuitive. And I think the reason is because there is no clear border there. They just have somewhat different features. Some have limited liability, meaning that the owners are not personally liable. But why would that be the decisive factor? I think it's rather like a continuum in a way. So some are sort of fuller legal persons and others are not. So those will be like some counter arguments.
Yes, it's my intuition. How many futures do you need to be a legal person?
Yeah. So that's your intuition, or?
Yes, and it is problematic in the context of boundary theory. Problem steps.
Right. Yeah, it's a good counter argument. Yeah, go ahead.
So I guess this is a bit of a follow-up of the question. And the worry is that, so my assumption about what do we need labels for is that labels sometimes are inference defects or license to make certain inferences. And on the orthodox view, we're criticizing the inferences connected to calling something a legal person are pretty clear. That is, whenever something is a legal person, it has to have a bunch of properties. Whereas if on your picture you call something a legal person, you always like nothing out of necessity follows from this, because in each case you need to look at the particular case. So isn't your ultimate end game getting rid of the category of legal persons altogether if we all need to look at each case separately?
That's a good question. This pertains to something that I call like legal personhood as a reason versus legal personhood as a conclusion. But first of all, I'm not convinced that the orthodox view really gives you that many inference tickets if you really consider it carefully. I mean, it depends somewhat what you mean, but I mean, so if we take the orthodox view to be the view that legal person is an entity that holds rights, then we can't really infer anything from that, right? So if we know that X is a legal person, all we know is that X holds rights. It's not like we can infer anything else from it. Right?
We can say that we can give the person something, or we can buy something.
Right, yeah, but that's then the other view, the capacity for rights view. Right, that's a different view. Okay, so the orthodox view, this is, yeah. So in that situation, we're then thinking of legal person in terms of a precondition for rights. But then, I mean, in my opinion, that's just a very incoherent view. It just doesn't work quite neatly outside of private law. So I think it. So if you sort of want inference tickets, then I would think of it in terms that you could, for instance, if you know that I think I don't have any slides on like this idea of subjects of, do I? Probably not. Anyway, if you want inference tickets, you can think that some incidents of legal personhood are inference tickets. So for instance, if you are a person in terms of tort law, then we can infer from that if someone harms you, you can sue for compensation. So that's like an inference to get. But I would sort of look at sort of smaller pieces rather than considering this very vague abstract capacity for rights. Yeah. Follow up?
Yeah, follow up. I was wondering about this a little bit. So it occurred to me that maybe there's a sort of fairly workable private law concept of legal personhood that does some analytical work because you can make certain inferences, at least they're certain default, a whole sort of set of default rules that go with legal personhood. But then if you turn to public law, maybe there's just a bunch of stuff. And every domain of public law has slightly different rules for what sort of entities it recognizes as legal subjects.
Right.
And there's just not going to be a whole lot to say systematically.
Yeah, I mean,
But it doesn't mean the private law notion might not be doing some work.
Yeah, I mean, I'm fine with that, but then we sort of realize that that's only one part of the whole. And I think like this might be different in common law, but I think like in civil law, so I think I'm mostly familiar with sort of how German scholars conceptualize this, but they have a whole bunch of really useful categories. So there's like, you know, Parteifähigkeit, so capacity to be a party to legal proceedings. Then there's capacity to be an active party, meaning that you can yourself represent yourself in proceedings. And similarly, like administrative law, whether you can be a party in administrative law proceedings, what you can do. So I think you can actually build these interesting categories, you know, also in other areas. And like I recently wrote a piece in Finnish on like Finnish criminal law, trying to actually create this sort of taxonomy of how it would work in Finnish criminal law. And that's what I would call being a subject of criminal law, because I want to distinguish those. So they're like, I think most of the typologies can be done in terms of, first of all, whether you're an active or a passive subject. So whether you're doing something yourself or rather sort of being the object of someone else. And then whether it's about substantive, meaning your sort of rights outside of the courtroom, or rather procedural. I think in terms of those categories, you can actually do a lot of work, but unfortunately I didn't prepare any slides about that. Yeah, I wonder if this addressed the worries at all. Very good questions. And I think that's like the question of the inference ticket question is a really good one. And I think what people often end up doing with the orthodox view is sort of having sort of unwarranted inferences. That's what they often do, in my opinion. So for instance, like the whole animal personhood trials in the United States is so much focused on the question of, so they are based on these premises that animals do not currently hold rights, but if we give them legal personhood, then they will be able to hold rights and we will have some grand consequences. And I think most of that is sort of not really obvious once you start sort of, you know, once you don't take those concepts for given. Yeah. Okay.
So your theory, as I understand it, allows us to explain the use of the term legal personhood in all domains of law. And the problem with orthodox view was that it couldn't do it. But maybe there is an alternative solution that in these different domains, for example, tort law and criminal law, there are just different concepts of legal personhood.
No.
And in this manner, we don't need to provide bundle theory. Because we have monadic concepts, not just many of them.
Right. Yeah, I think that's a reasonable view, and I think, for instance, again, it's the same sort of symposium. So Raphael Fasel, I think, had something like that in mind. I think it's a good counter argument, or a good argument, and I guess my counter argument would then be that many of these incidents are connected to each other in various ways. So for instance, so if you're say criminal law, if you have a sort of personhood status in criminal law, that means that that's also related to your status in tort law in various ways, and it's also related to your status in property law. So you can't really be eligible to receive compensation unless you can own property, for instance. And at least in Finland, like you can receive compensation in criminal law trials. I think maybe in the common law these are like distinct procedures, but in Finland you can sort of have if someone harms you in a criminal manner, you can the prosecutor can demand both like punishment and compensation from the wrongdoer in the same trial. So I think it's like connected in such various ways that's why I would tend to think of this as a interconnected whole. Yes.
If I may, another follow-up after what you said about the legal personhood people, I was wondering if they care about calling them as legal persons for legal reasons, which is what you seem to be criticizing them for, or because you call someone a legal person, like the legal personhood serves as this badge of honor, like that this substantial social change to accept them as legal persons, even if they think you're right, this might not be the best way to go from a legal perspective. So I was wondering if you could say more about this like symbolic meaning. We actually been thinking about Bachelor's project about marriage.
Yeah, I mean, the term person is of course very sort of politically, morally loaded. And definitely, like the question of what we call persons it can serve as a kind of honorific. I think that's true. But then on the other hand, I mean, yeah, I think that's true. I think it seems to me that like in English, it's more loaded than in Finnish, for instance. But it has to do with the language, and because the word in Finnish, the term henkilö, it just doesn't sound as I don't know, as important as in English for some reason. I think like being rights holder is much more important in Finnish. So I think it's probably a matter of language as well. But yeah, go ahead.
I also question how, maybe I missed something, but how you theory exactly explain this evolution of legal personhood, like the act of recognition that marriage and not married, but married women can be assessed as legal persons, because there are also some court cases from the end of, I don't know, 19th century in the USA that said that women within the coverture system or this system of one-flesh marriages can hold rights and be an actor in the public sphere. So, for example, can exercise the role of patronage or something like that.
Yeah. How would you explain that? Well, I mean, actually, I've got some useful slides in the next part, but I think, well, first of all, you could say that women still had some rights. If you look at these, they probably had some of these rights still. So women's body life and personal integrity were still protected to a limited extent, for instance.
Well, for most of the time, for example, rape law was regulated in the manner that not the wife, but the husband can be a legal actor, and there was some provisions that are strictly connected with property law. It was the injuries in the property law, not injuries in the body or personal integrity.
Yeah. So I mean, I agree, and that I mean, so under coverture, I think you could still find like some semblances of these, but it might be very fair to say that under coverture, women were not legal persons. You might draw that conclusion. I mean, it was terrible, right? But you might want to draw that conclusion. Whereas in Finnish law, you had something called edusmiehys, which wasn't that extreme. It was more like that women were like passive legal persons, but they could not really do anything, say, with their property, unless, except through their husbands. So in a way, their husbands sort of were their active representatives. So I think it depends on the country a lot, or the jurisdiction. But actually, I think there will be maybe a useful slide in a bit. Any further questions?
So you will the Finnish term for a person?
Henkilö. Right. So can anything be a legal person? So this is something that it's a funny thing because you guys have had excellent counter arguments against my theory, but often when I present it, I receive no counter arguments with regard to the sort of cluster understanding of personhood. But then I present this. I say that rivers cannot be legal persons, and that's when I start getting like, how can you say that? You know, that's terrible. So we'll see what you think about this. But this is sort of the dialectic here is that I think very many lawyers and jurists seem to think that have what I call an everything goes approach to legal person, meaning that the law can turn anything into a legal person. That seems to be the intuition of many jurists and so on. So, you know, if the law decides to make this baseball cap into a legal person, it could just do that. This seems to be the intuition of many. And I've tried to understand this view, and I think that there are two main arguments in favor of it. One is the so-called corporate argument. So, I mean, we have corporations, right? And they're products of imagination, or they're legal fictions or something. We can just create corporations out of thin air. Therefore, anything can be a legal person. You know, it's just like, this is not a strictly logical. I mean, you need to have some additional premises, but at any rate, it's an enthemy. And then there's something that I call a deference argument. So deference means like paying respect to someone, and I think in this case it would be paying respect to the like deferring to the legislature. So the intention or extension, or the main intention meaning the meaning of legal person, extension meaning who or what is a legal person, and the main meaning who or what can be a legal person. I've here capitalized legal person to mean it's a concept. So these things can be determined by legal authorities. So the legislature can freely decide these things. And therefore anything can be a legal person if the legislature so decides. But I think these arguments are both mistaken, and while doing so, I hope to discuss some further features of legal person. I'll first discuss corporations. Oops. So first of all, I think this is the source of much confusion regarding corporations, which is that the word can refer both to a legal arrangement, a legal bundle, but it can also refer to an organization, a group agent, with a specific legal status. So if we talk about the corporate culture of Nokia, we're talking about an organization with a specific legal status. But if I say that let's start a shell corporation to pay less taxes, I'm not talking about an organization in the same sense. The shell corporation is not like it doesn't have a company culture, for instance. Okay, it's just a bundle of stuff, of money and that kind of stuff, like rights and duties, basically. So here is then. This is where I sort of discovered a rather deep ambiguity about legal person, which I then tried to resolve. And this is by introducing a new term, the term legal platform. So a legal person, like myself, is always attached to at least one legal platform. Legal platform means my rights and duties together. And these legal platforms are then integrated, separate, and named. And so here is an example. So Matti Meikäläinen is Finnish for John Smith, you know, Matti Meikäläinen. So he has what I call a natural legal platform called Matti Meikäläinen. So this is like his legal identity. This is his legal rights and duties, okay? So it's integrated in the sense that if Matti doesn't pay his debts, he can lose his house. So the rights are connected in various ways. But it's separate from other platforms in the sense that if his wife or children, or if he defaults, so if he goes bankrupt, his wife or children do not have to pay normally his mortgage, barring special circumstances. So what if Matti then starts a dental practice? He wants to keep his dentist rights and duties separate from his sort of rights and duties qua natural person. Well, in that case, he can create actually two legal platforms. He can have Matti Meikäläinen, which includes the sort of personal rights and duties, but he can also have access to Matti Incorporated, which is a one-person corporation. And that contains the rights and duties that came to his dental practice. Okay? I think this is in a way quite straightforward, but people very often get confused about this, in my opinion. But if you then have this idea of a legal platform, you can do all sorts of analysis with help of it. So here's Matti Meikäläinen, and here's actually a coverture case. So in this case, rather than there being one person with two platforms, in that case, it's like two human beings, but actually just one legal platform, which is called, in this case, John. So Jane sort of disappears in a way. So it's John. Jane becomes part of John's legal existence in a way. And then with slavery, the point here is that if we have a slave named Andre, then in a way the slave doesn't almost have a legal platform because the slave doesn't have that many rights. So since we're someone's gonna talk about group agents. Yeah, okay, go ahead.
I have a question regarding children, because now I think one and other legislators, there is this thing that when you have a child, parents can decide something for this child, right? And how would you describe this platform for this child? Does the child have one platform for themselves? There is a situation from the 19th century England. There is one platform for a child and the parent. How would you see it?
I would say they're separate platforms, but the parents control the child's platform. I even have a slide for that coming up. But anyway, I think someone's going to talk about group agents, right? Is it Krzysztof or someone? Yeah, okay. So I'm going to keep this very brief. But I have this example. So let's say that we have a band with 4 members.
And I think something totally opposite.
Totally opposite
To what you're going to say.
Okay, that's good. Then I'll skip most of this. I'm just going to say this, that they start a group. This can be called a group agent, this band. And normally if you start a band, the band doesn't have its own legal platform, right? So I played in a band, so I know this. The band didn't have its own legal money, for instance. The money was ours. But if the band members didn't want to start a corporation, then the group agent receives its own legal platform in a way. So it receives its own bundle of rights and duties. Okay. So this is now where we get to this sort of ambiguity about legal personhood. So sometimes when we talk about corporations, we mean the sort of group agent that has a legal status, specifically the status of a corporation, okay? But sometimes when we talk about corporations, we just mean only the legal platform. So if we talk about the dental practice that I run alone, then it's not, it is a corporation, but it's just a bundle of rights and duties. It's nothing else. It's not an organization or anything like that. But in the case of the metaphysicists, the whole thing is a corporation. So there's are you following me here? There's like two different senses in which you can use the word corporation. And I think, so we were discussing the corporate argument that law can make anything into a legal person because we can create corporations out of thin air and thereby make anything into. So, but the problem here is that we can make infinite numbers of corporations, but only in this sense. We can create infinite numbers of bundles of rights and duties, but that doesn't mean that anything, anything can be sort of attached to those rights and duties. If you're following, yeah. Merely the fact that we can create bundles of rights and duties and call them, say, this one. I can create a bundle of rights and duties and call it 1 + 6. This is named my phone. But it doesn't mean that this phone becomes a legal person. It just means that there is a bundle of rights and duties called 1 + 6. That's it. And so Kelsen would actually prefer my alternative too. Because for Kelsen, a person is simply a bundle of rights and duties. It's completely in the realm of normativity. So if you take Kelsen very seriously, you can't say that I am a legal person. The only thing you can say is that there is a person, imputable to me or something like that. And I'm not sure, like, you can do that, but I'm not sure, like, how helpful that is. Right. So that was the corporate argument and how I tried to rebut it. So merely because we have corporations, it's not always obvious that anything can be a legal person really because we have corporations. Okay. And then there's the deference argument, which I think is quite interesting, sort of methodologically as well. So anything can be a legal person because the legislature can just decide on legal concepts. Go ahead.
I think about the previous part.
Yeah.
About your consent and your legal person. Would you say that Lisa Kurki is polysemous in English? I mean, if your view is true, then when I'm saying this Lisa Kurki, I might be referring either to your flesh and bones or to your legal platform, right?
Yeah. So
I'm saying
it's not obvious which
so
one.
when I'm saying this Lisa Kurki owns a house,
Yeah.
the sentence on you is between a true sentence and a false sentence, depending on what I mean by Lisa Kurki.
Yeah. So if you were referring to me, like flesh and blood, then it would be probably true. But if you're referring to my sort of bundle, then it would actually be false in the sense that my rights and duties don't own anything, but rather they sort of constitute ownership or something like that.
No, wait, so you're saying that flesh and bones was talking about your legal platform?
So I'm not sure if we're talking about Kelsen now or my views.
Yeah, sorry.
Okay. So if you're saying that Lisa Kurki owns a house, then I think you're referring to, in a way, me plus my legal platform together, which together comprise my legal personhood. Or what do you think?
I was thinking about your view.
Yeah, I wasn't just sure, like, what you're getting at. Hopefully I got it right. But anyway, so this deference argument, this is quite interesting. So because normally I think it's sort of bread and butter, unless you're doing general jurisprudence, it's bread and butter that you sort of don't take what courts say at face value. So that you don't take it for granted. For some reason, here, people seem to think differently. So here is an example. I mean, this is actually very general. This is not only about this topic, but Michael Hartney, who I don't really know, writes that the ultimate touchstone of all legal statements and of the meaning of legal terms is the acts and especially the utterances of these legal authorities, like the legislature. No argument, philosophical or otherwise, can ever prevail against the pronouncement of the competent legal authority. This is especially true of the term right. The utterance of a legal authority that a right is being conferred is conclusive evidence that legal right has been conferred. Whatever legal authorities say is a legal right is a legal right, whether this agrees with what philosophers would say about moral rights. If a statute says that trees have rights, then trees have certain legal rights, whether we consider this to be morally defensible or even morally possible. And I must say that I disagree. But some of you probably think this is very reasonable. I think it's quite strange. Because why couldn't the legislature be confused about things or be wrong? So for instance, if we think about ownership, so I think probably the most popular analysis of ownership is that ownership is a bundle of rights. So it consists of various smaller incidents or elements. And so the legislature could write in the civil code that ownership is not a bundle of rights. But what would that mean? I mean, it might have some legal effect. So it could mean, for instance, that what we mean by ownership is only one specific element of what was earlier called ownership or something. But legal scholars could just say that, well, no, it is a bundle of rights. You're mistaken about the nature of ownership. That's perfectly possible to say for a legal scholar. So it's definitely possible to disagree with the legislature. Yeah, and I already mentioned this point about explication, but this is like, happy to hear your comments on this, by the way, but this is in a way what I perceive to be the role of clarificatory jurisprudence, like a very rough sketch of it. So we have authoritative legal materials, like statutes and so on, and then through interpretation, we find out the norms of the legal system. So most importantly, duty conferring, and duty imposing and power conferring rules and principles and so on. But we don't have to, as legal scholars and especially as jurisprudents, we don't have to stop there. Rather, we can analyze this both and think of what is the sort of best exposition or explanation of both the norms and the legal materials. So we can for instance criticize the concepts that the legislature is using, saying that these are a bit confused concepts that, you know, the legislature here talks about rights and here about freedoms, but actually the legislature is talking about the same thing or something like that. We can do all sorts of things. And we are not here sort of challenging the legislature's authority with regard to the fact that it's the legislature who creates the legal norms, okay, by enacting authoritative legal materials that are then interpreted. But we can still provide a completely different exposition of these things as legal scholars, okay? So here is then a kind of an ad absurdum argument. So we have a legal system and the corrupt elite set up a legal person and they call it the Great Spaghetti Monster. And they sort of pretend that it's some kind of religion. But actually the point is to divert funds to this legal person, this Great Spaghetti Monster, so that they can use the money for their own purposes and avoid taxes, okay? So do we as legal scholars of this country now need to conclude that, okay, then the Great Spaghetti Monster is a legal person? Or can we say instead of, okay, there certainly is this kind of arrangement. There is a legal platform that we call the Great Spaghetti Monster, but what doesn't follow is that this dude here is now a legal person because it doesn't exist. Okay, so we can still be critical while accepting that this has legal effect, but we can still be critical of how exactly to sort of understand it overall. So there is a legal platform entitled the Great Spaghetti Monster, but to whom or what does it attach? Okay, who is the flesh and blood entity here? Oh, not necessarily flesh and blood because it can be glue based, but still, like, who is the entity sort of in the physical world? So we could actually argue that it's not the Great Spaghetti Monster, but rather something else. Yeah.
Okay, so
being a general philosopher, I have a question.
Yes.
So, do you mean, because I got this feeling from what was before, but maybe it was just phrasing,
Yeah.
that the term legal person must always have some sort of spatial temporal entity as its denotation that can not abstract objects beyond the person. So that's what I got from the last sentence, but I'm not sure whether just phrasing matter or the actual metaphysical commitment was.
So, so I so sort of my cards on the table. So I think in order for you, so there is something that needs to be a legal person, okay? And what I would argue is that it can be a passive right holder, so it's just a baby or an animal, or it can be an agent, and those would be either human beings, individual human beings, or group agents, maybe also robots in the future. And then, yeah. So if a group agent is also spatial, okay. Yeah, that's what I was thinking about.
Yeah.
But I mean, you could of course go argue that. I think temporal, yes, but you could maybe argue that it doesn't necessarily have to be spatial. You could maybe argue that. I wouldn't be convinced by it probably, but you could maybe argue. But anyway, yeah, that would be something that I'm claiming. Yeah, go ahead.
If I'm not mistaken, in certain continental systems, it is possible to set up a company with shareholders of which are just other companies. What would you say about that?
Yeah, so I mean, there's the issue of whether it's a legal person or just a legal platform. Okay, so you need to sort of disambiguate those two things. Yeah. Yes, go ahead.
Okay. So because I have an impression before that you argued that your conception is going to be the most encompassing. But now it turns out that it also has a negative reflection, because you are excluding also some things which were called personhood, you are excluding them from the
Yeah.
Okay. So it also is funny for me, the contrary to consequence of your theory is the problem of foundations. Because the corporations, of course, with some people, or at least fictional people like other companies.
Yeah.
But foundation is founded on things, not on people. Not on
Right. I have a slide on foundations. Go ahead.
Okay, I was going to ask about foundations as well.
Okay.
But a clarificatory remark. So, many philosophers now say you can have a temporally extended abstract objects and fictional characters.
Right.
Primary examples. So Harry Potter is an abstract
Yeah.
object,
Oh, okay.
but it came into existence when
Okay.
Rowling wrote the books.
Yeah. Okay.
So foundations might be a nice example of a temporally extended abstract object.
Okay. Interesting.
Yeah.
Yeah. Okay. I'll get back to that in a second. I think I still have 20 minutes. So I mean, so this would be basically the argument. So first of all, I think the sort of maybe even more important thing is that if you want to show that something can be a legal person, you need to actually provide some substantive arguments for it. You can't just say that, well, you know, it's about law, you can do whatever you want, okay? So you can argue that maybe Harry Potter could be a legal person, but you need to provide some arguments for it, rather than just, you know, declaring it by fiat. And then my argument would be that in order to be a legal person, one must be able to hold, I haven't really sort of fleshed this out here, but you must be able to hold either claim rights, duties, or competences. Claim rights in the interest theory sense. So the question then is that can, for instance, non-existent monsters hold claim rights? I would say no. I mean, of course, they exist qua fictions, but they don't exist qua actual monsters. And this is then a question of rights theory. But anyway, now a couple of words on legal positivism, and then I'll show more pictures. So is this then incompatible with legal positivism? If I say that the legislator cannot turn this cat into a legal person, the legislator cannot do that. So is that against sort of tenets of legal positivism? You could maybe argue that. I would say it's not. The reason being that we need to think about what exactly legal positivism is all about. So I think legal positivism is, well, it's especially about the norms of a legal system. It's a claim about the contingency of the norms of the legal system. Okay, but note that so it's not a claim about how those norms should be understood. So power conferring and duty imposing norms are sort of in the Harting tradition what I think legal positivism is all about. So those are system contingent and they depend on, you know, the rule of recognition and legislative decisions and so on. But that doesn't mean that legal scholars need to take norm propositions. I think you've heard the distinction between norms and norm propositions enacted in statutes at face value at all. So a legal positivist could, for instance, argue, and this is not my view, but I mean, a legal positivist could say that, okay, we have a bunch of statutes talking about the duties of corporations, but actually corporations don't exist. They are only individuals. So legal positivists could say that, in fact, what the legislator is doing here is creating these complex relationships between individuals. You could be a legal positivist and still say that. You could refuse to take at face value what the legislator is saying. And I think this is the same goes for claim rights that correlate with duties. So you can say there as well that okay, so this example is now river. The Wanganui River in New Zealand. So clearly, if the legislator creates a new legal person arrangement called the Wanganui River, then something happens, right? It has some legal effects. But the question still is, what effect is that and which parties are involved? So here are now some examples. So here's, for instance, how I understand passive legal personhood normally. So you have, here's Lauri, the passive legal person, he's a baby. Here is his legal platform, his rights and, oh sorry, beginning, let's see. There's Lauri, here's his rights and duties, and here is his representative. So it's this sort of triangular model here. So Matti is his representative, he administers Lauri's rights and duties, but it's Lauri who actually holds the claim rights here, if we think that babies can hold rights. Here's a foundation, S, so registered foundation in Finnish. In this case, I think there is just a purpose and a legal platform, and that's it. There's like nothing further that is the foundation. So you can maybe argue that it's maybe an abstract object, and maybe you could argue for that. I think there just is a bunch of property and someone administering it according to its purpose. But maybe you could provide a better explanation. Here is animal as a passive legal person. This works. I think this works very much like the baby. Okay, the baby example. I think it's very similar. You have a living sentient being that's represented in various ways. Oops. But then we come to the question of whether, for instance, nature or a river can be a legal person. And here's the thing. So if the New Zealand legislature enacts a law stating that there is now a legal person called Wanganui River, for instance, clearly we get a new platform in the world. We have a new bundle of rights and duties. But the question is, sort of who holds those rights and duties. Is it really the river itself? Is it the body of water? Or is it something else? And this is something that we as legal scholars can question. Is it who actually holds the claim rights? In this case, it's not Matti probably, who's the representative, but there's like a body that's set up to administer. So have you heard about this one on the river thing? Yeah. So I mean, it's this idea that it's a holy river for the Maori people, and what they did in New Zealand was that they set up a new legal person, or I would call a platform, called Te Awa Tupua. And what they did was, I think there's one representative from the Crown and one representative from the Maori tribes, and they together administer this new entity. And it can, for instance, receive ownership of all the Crown-owned riverbeds of the river, and it can sort of be involved in all sorts of cases involving the river. It can try to pursue people who pollute the river and so on. Okay, so the question is now, is the river itself, this body of water, running water, is the river itself now a legal person? And I think some people would say yes. The Maori would probably say yes, because they think it's quite reasonable that a holy spiritual entity can be a legal person. Me, as someone who is a materialist, would say, well, probably not. Maybe I'm not going into all of this, but so, well, for instance, if we think of the river as a body of water, then we can ask what is in its interests. Maybe some of you think that even bodies of water can have interests. To me, it's not obvious that merely water can have interests, that it's better for a body of water to be in some situation rather than another. So to me, it's very hard to understand how we could sort of attribute, say, claim rights a la interest theory or will theory to the river. So can the river demand its rights somehow? And I'm talking about the river itself, not about representatives, but the river itself do these things. That doesn't seem likely. So here are then some alternative ways of thinking about this river example. So even though maybe the legislature says explicitly that this river is not a legal person, but we as legal scholars can still say that, well, oh, sorry, here's some Finnish left, sorry about that. So we can still say, for instance, that some collective is actually the relevant right holder and thereby the legal person here. So we could say that maybe the Maori tribes together are actually sort of the collective right holder here, but we can say that the human beings and the animals in the area together are the right holder here. So they together are the that hold the claim rights pertaining to this platform. That's one way of thinking about it. Or maybe it's like a foundation. So it's just a separate platform that some people are tasked to administer in a certain way, and that's it. That no one is the legal person per se. It's just a platform. That would be another way of thinking about it. Anyway, thanks. There's